What changed in family-based immigration law in the United States in 2025, and what can we expect going forward in 2026? That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. So, what actually changed? We're going to talk about what actually did change. I know there was a lot of anxiety and worry and a lot going on in the immigration landscape in the United States in 2025, but what actually changed? What are some common misunderstandings or misconceptions? And what are some realistic, grounded expectations for 2026 going forward in the family based employment or in the family based landscape? So, first, let's talk about what actually changed. Like I said, I know that there was a lot of anxiety. I lived it alongside my clients, a lot of anxiety, confusion, seemingly changes happening every single day. Sometimes it literally was a change day by day. But it's important to keep in mind that there were no changes, no significant changes, at least with the cases that we handle, in the statutes or the regulations. So the way that immigration law works, the way that law works, is that there is the Constitution, of course, and then there are statutes, which is the law that Congress creates, and then there are regulations, which are the rules that the agencies implement and come up with and implement. And yes, there were regulatory changes for sure, but the bottom line is that in general, in US family based immigration, the same people who were eligible for benefits previously, prior to 2025, still are eligible. Really, the changes that we saw were more in the processing times, policy changes, operational changes, things like that. So, what did actually change? How cases were processed and moved changed a bit. One thing I want to touch on is birthright citizenship, because I know that's still at the top of a lot of people's minds, understandably. There was an executive order about birthright, trying to end birthright citizenship earlier in 2025. That was challenged in federal courts, and it has not been implemented as of right now. It's possible that that would change later, depending on litigation. But as of right now, birthright citizenship still stays in place, and has not changed, even though there's been a lot of discussion about that, and there was the executive order and litigation around that. So it might change, but for right now, it's still in place. So other things that did actually change, or what did actually change, is USCIS processing times, and they actually didn't change, to be honest. USCIS processing times, especially for family-based cases, are pretty inconsistent. A lot of times it depends on the local service center, or the local field office rather, and how busy they are, but it's inconsistent. So it's really difficult to compare your case to another person's case, which I know everyone loves to do, including me. I haven't been through the immigration process, but when I'm going through different life events, it's natural to want to talk to other people who are going through it. But it's really difficult to do that in immigration because every case is so different and different field offices are different. So what we have seen are they're inconsistent. That's not new to 2025. And I don't expect it to change in 2026. It's been that way for a very long time. In general, what we're seeing in our practice is that marriage-based I-130 and I-485 filings are going quickly. So quickly that sometimes we have had clients, or we ourselves have thought, oh my goodness, is there something wrong with the case because it's been scheduled for an interview so quickly? So I'm talking about like less than 6 months from the time to filing to the time of the interview and ultimately approval. That, of course, is subject to change. Definitely not the case for every single case, but it is what we're seeing just in general. In addition, naturalization continues to be fast. With our local field office, generally from the time we file to the time of an interview is around 3 to 4 months. Again, every case is different, subject to change, but that's what we're seeing in general. So that's really nice. With I-129F petitions, the petition you start to file or to start the K-1 fiance visa process, those are taking a long time in our practice, and we're seeing inconsistent processing times. And I-130 petitions are still taking a while to be processed. So bottom line is processing times are all over the place and inconsistent, but going fast for certain types of cases. May change in the future, but we'll take it for right now. So we are also seeing that interviews are being required for marriage-based cases. Previously, they had been waived if the cases were well documented, but we're seeing for every marriage-based case, that the interview is being required. What's important here is that there's solid documentation, not just for marriage-based cases, but for family-based cases in general. There's solid documentation. There's enough documentation, but not too much documentation, and that you're presenting information that is consistent with what you have presented before or what's available in your history in terms of documentation. In terms of naturalization, the process of becoming a US citizen, there, as you probably have heard, is a new citizenship test, or new naturalization test rather, for the history and civics exam that was rolled out in October of 2020. It's now 120 questions, sorry, October 2025. It's now 120 questions instead of 100, and some of the questions are a bit trickier. Ultimately, it's still a matter of answering questions. Yes, you can only see eyes. I apologize. It's the format. I don't know. They're different layouts. I don't know what to do about that. Anyway, hopefully you can hear my voice. So naturalization, there was a new test in October. They say that they're going to start neighborhood investigations. Again, I don't know what that is. Not that I don't know what that's about, but I haven't heard of that happening. So we'll have to see what happens with that going forward if we see some of that happening. Fortunately, right now we have not seen that happen. In addition, they say that they're going to have increased scrutiny for naturalization. We are seeing that in practice as well, the increased scrutiny for naturalization. In addition, it may not be enough going forward to show that you haven't done anything, quote, bad. And when I say bad, I'm talking about the good moral character requirement in general. Historically, we've only had to show that a person has paid their taxes and that they have not had certain criminal charges or convictions, things like that. It may not be enough to show that. Going forward, you may have to actually document that you have contributed to the community and that you are a person of good moral character. You may have to be more proactive in documenting that. Other changes that have happened, so we're still in Section 1, changes that we've actually seen in 2025, the travel ban. So in June of 2025, the Trump administration announced a travel ban for certain countries, a full ban for 12 countries, a partial ban for 7 countries. In December of 2025, more countries were added. 5 other countries were added that have a full ban, and 15 were added that have a partial ban. In addition to the travel ban, USCIS, the agency here. So the travel ban, remember, affects, depending on the wording and the specific country, it affects individuals who are entering the United States as immigrants or potentially as non-immigrants, people with temporary visas. And again, it's different depending on the country and the date, to be honest. Anyway, the USCIS said in December that they are pausing the adjudication of certain applications for immigration benefits, meaning if you filed something with immigration and you are a citizen of one of these countries that is, quote, a country of concern, meaning on the travel ban list, then your application or your petition may be paused. The adjudication may be paused so that they can do more vetting. That's the extent of the information we have right now. That really has just come out, like I said, in December 2025. And then there was an additional memo dated January 1st of 2026. So we have yet to see what the actual implication of that will be. I'm sure that there will be litigation surrounding that. So what are some common misconceptions regarding US immigration? One is that family-based immigration, or US immigration in general, is shut down, that it is not possible to come to the United States, not possible to get a green card, not possible to have your applications adjudicated. That is not true as a blanket statement. It is not true. You absolutely can file. So even if you are from one of the countries that is on the travel ban list and therefore your application is potentially being held by USCIS, you can still file. There's nothing that says that you can't file. It's that it won't necessarily be adjudicated immediately or on the timeline that we anticipate, unfortunately. But things are still happening. We're still every day getting approvals for marriage-based cases, for individuals who have loved ones overseas that are entering on immigrant visas, the employment authorization documents. We're still getting approvals on a regular basis, and that I don't foresee that changing in the near future. It's just that there are differences in the way cases are being processed and handled, and of course, different rules and policies that are popping up. Another misconception is if you file now, that the case law or the way the case is being handled will change mid-case. It is possible that that would happen, but more likely, most of the time, when there's a change in a policy or the way a case is treated, that type of thing, it applies to cases filed after that change is made. So yes, the change may happen overnight. We may not have any advance notice that the change is happening, but almost always, not always, but almost always, it affects only cases that are filed from a certain date going forward. So it's not true necessarily. It's unlikely to be true that if you file, something's going to change that will significantly affect your case midway. I've talked to a number of people, in 2025 who are understandably hesitant to file, not sure exactly what's going on. And I think that's a mistake. If you're eligible and you know what you want, you have a strategy, you have a clear plan, and you know that you're eligible, I would say go ahead and file, because you know what the situation is now, and it's more likely to change later and potentially prevent you from filing. I know I've had a number of people who have waited and have regretted waiting because the policy has changed or the processing time has changed or something like that. And then finally, another misconception is that it's just forms. It's just paperwork and you can do it on your own. Absolutely. There are people all the time who file on their own without a problem. There are also all the time people who file on their own and create a huge problem. Sometimes that leads to deportation orders. That's an extreme example, but it absolutely can happen that you land in immigration court because you have made a mistake with your paperwork. So it is not just paperwork. It is not just forms. There is strategy and planning that goes into this. And it's nice if, it's possible to have somebody, an experienced legal professional, walk you through this, to be by your side, to answer questions, give you updates, provide guidance along the way. So what to expect going forward in 2026. I think we can continue to see inconsistent processing times. Again, that's not anything new to 2025. It's just generally how U.S. immigration is. I do expect we'll continue to see policy shifts and changes that happen really quickly. So as I said before, if you have a strategy, you have a plan, you know that you're eligible and you're planning to file now before something changes that prevents you from filing, that makes the process more difficult, that makes it take longer. It's important to submit a strong initial petition or application. Once you submit something to USCIS, that's kind of it. You can't withdraw it. You can't retract it and pretend that that they never saw it, whatever it is that you're submitting. So it's really important you have a clear plan and strategy going forward from the very beginning. And then staying informed about changes that may come up in the future. It's important that you're getting information from accurate sources. There's a lot of information out there. Every day I have consultations with people who say, hey, I was trying to do this myself, but there's so much information online, and just talking to people that is conflicting. I want to make sure that I have the correct information. So make sure you're getting information from a correct source and make sure it's applicable to your case. Even if the information is, quote, correct, it may or may not actually apply to your particular situation. So bottom line in 2026 is that kind of the for 2026 in terms of U.S. Immigration, family-based immigration, is you want to be strategic and intentional. This is the time to be proactive, to be grounded, to have some clarity in your planning, and to have solid guidance, somebody to provide you solid guidance around the way. And we would be happy to do that if you are looking for an immigration attorney to help you with your family-based or employment-based immigration filings. My name is Emily Sumner with Sumner Immigration Law. We serve clients from around the world and around the United States with employment-based and family-based immigration matters, and we'd be happy to help you. We have information on the next slide about how to contact us if you have questions, if you want to set a time for a consultation, and we would love to hear from you. Again, Emily Sumner from Sumner Immigration. Until next time.